Personally, I feel that the Montgomery ruling was an inevitability. Firstly, because of the regulatory stance to consent that many in the various professions were ignoring, and let's be honest, we were ignoring it, but also our adversarial legal system kind of demanded it. You just can't have a highly litigious system such as ours, where medical and dental professionals are obtaining proper valid consents differently in the eyes of the regulators and of the lawyers. But a question that needs to be asked is whether Montgomery was the right ruling, or whether it will cause more problems than it solved. Montgomery versus Lanarkshire Health Board was a 2015 Supreme Court case that has far-reaching implications for consent. This is especially so for dentists due to the wide variation in treatment options we often encounter. It involved the care of Nadine Montgomery, who was not specifically warned of the risks that her diabetes presented to a vaginal delivery at the end of her pregnancy. The specific risk that resulted in the harm to her newborn child was shoulder dystocia, which caused umbilical cord compression and cerebral palsy. Due to the foreseeable problems during the birth, the child was in fact born with cerebral palsy. Nadine sued for negligence, arguing that if she had known of the increased risk, she would have opted for a caesarean section. Now, the case failed in the Scottish courts, and it was only upon appeal to the UK Supreme Court that her case was successful. In essence, the case has changed the common law on how medical consent should be achieved and, in my opinion, cemented and enshrined an impossible standard for dental professionals. It established that, rather than being a matter for clinical judgment to be assessed by professional medical opinion, a patient should be told whatever they want to know, not what the doctor thinks they should be told. Now, I'd like to take a moment to discuss the path the English common law took to reach the Montgomery ruling. Prior to Montgomery, the courts had held a different opinion on consent and negligence. The first case of any note was Bolam versus Frerne Hospital Management Committee, which was in 1953. A case for negligence brought by Mr. Bolam, who suffered harm whilst receiving electroshock therapy. The legal profession has reportedly never been a fan of Bolam, arguing that it reinforced medical paternalism whilst giving too much protection to the doctors. Now, at the time, Mr. Bolam's solicitor had argued that the claimant should have been restrained and sedated during his electroshock therapy. However, the judge did not agree, because it was found that a reasonable body of opinion did not feel such measures were routinely needed. In dismissing the case, Justice McNair stated, "He is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a reasonable and responsible body of medical men." I didn't put an accent in there, I couldn't be bothered. So in the process of obtaining consent, all a dentist had to do was show that his consent process and the treatment modality were in accordance to that accepted by a reasonable body of clinical opinion. The opinions of the patient, it could be argued, were secondary to the concerns of the medical professional. This is where we derive the Bolam test from. The law states that the medical professional has a duty of care to reach a required standard when treating his/her patient, but it is the profession through peer opinion that sets the standard of that care. It can be argued that the Bolam ruling was an adaptation of the ruling in the Scottish case Hunter v Hanley in 1955. In this case, Lord Patrick outlined the 3 tests needed to prove negligence. 1. It must be proved that there is a usual and normal practice. 2. It must be proved that the defendants had not adopted that practice. 3. It must be established that the course the doctor adopted is one which no professional man of ordinary skill would have taken. The Bolam ruling was reinforced by Lord Scarman in Maynard v West Midlands in 1984. The case revolved around a patient presenting with tuberculosis-like symptoms. Instead of waiting for results on sputum tests, the medical staff involved went ahead with more invasive tests that resulted in the patient being harmed. The expert opinion brought by the defence stated that the actions of the clinicians were reasonable, despite there being opinion that said otherwise. Lord Scarman judged that it was to be accepted that there were differences of opinion, and that these counter-opinions didn't matter so long as a reasonable body of opinion supported the practitioner's actions. The case was found for the defendant. The first real test of the Bolam ruling came with Sidaway versus Board of Governors of the Bethlehem Royal Hospital in 1985. Whereas Bolam had been more an issue regarding the actual way treatment was provided, Sidaway was a case primarily about consent. The case revolved around a surgeon who performed a cervical spine decompression without warning the patient of the risk of paraplegia. Said paraplegia occurred, and the patient sued, stating that if she had known the risks, she wouldn't have gone ahead with the operation. The patient was in essence demanding the courts respect and acknowledge her perceived right to autonomy. In Sidaway, the court ruled that the Bolam test was the correct test when judging consent issues, and the case was found for the defendant. It was deemed that a reasonable body of opinion would not warn about the risk of paraplegia in this particular operation. Personally, I think the real first signs that Bolam was under threat was actually in an Australian High Court case, Rogers v Whittaker, 1992. This was a ruling that determined that a material risk was something that a reasonable person would attach significance to, and that it wasn't perhaps for the clinician to determine what a material risk was. This was, in my opinion, a warning of things to come, because we all know what happened then. It was another 4 years before the first real cracks in the Bolam defence appeared via the English courts. In Blytho v City and Hackney Health Authority in 1997, the issue of the legitimacy of expert witnesses and their evidence was raised. Although the judges found for the defendants, the Blytho ruling added that although Bolam was still valid, the expert witness evidence that was offered in defence would need to be rational and logical. This in turn meant that the treatment itself would need to follow the same rationale. This ruling was further reinforced in the 1999 Wolf reforms, which governed how expert witnesses had to behave, as laid out in Part 35 of the Civil Procedure Rules. The reforms removed the risk of the expert witness for hire and made it mandatory that all expert witnesses gave their evidence for the benefit of the court, not the client. It also limited the extent that solicitors could influence the reports written by expert witnesses. They also established a legal requirement for expert witnesses to declare their ability and competence to comment on the matters at hand. On a side note, until very recently, there has been a very real issue with GDC expert witnesses, many not seeming to understand their remit and thus displaying severe bias in their reports, which has been detrimental to the profession on the whole. Another test on the level of risks involved in care was seen in Pearce versus United Bristol Healthcare NHS Trust in 1998. As with the Montgomery, this was a case involving a pregnant woman who suffered harm at the hands of medical staff. She claimed that she was not warned of the risks of stillbirth, and that had she been warned, she would have insisted on a caesarean, very much what happened to Nadine Montgomery. Although the judges found for the defendant, there were clear indications that patient autonomy was starting to be pushed ahead of medical paternalism. Chester versus Afshar, 2004, gave a further warning of where the common law was heading when it came to consent. The surgeon in question was found to have failed to warn about the risk that resulted in the surgery he performed. Although the surgeon had not been negligent in his performance of the operation, the claimant showed that, had she been warned about the risk, she would not have had the surgery done at that time. This was thus again a consent issue. As Lord Walker stated, bare but-for causation is powerfully reinforced by the fact that the misfortune which befell the claimant was the very misfortune which was the focus of the surgeon's duty to warn. Lord Hope had similar views. Basically, the surgeon was found to have violated the patient's right to decide what was right for them. Clearly, the public's and the judiciary's acceptance of medical paternalism was coming to an inglorious end. Unfortunately, and I can only speak from personal experience here, it seems the medical field in particular have been slow to understand this. The next case to come along was Birch versus University College London Hospital's NHS Foundation Trust, 2008. This case involved the risk-benefit analysis of different procedures. In his conclusion, Justice Cranston found for the claimant. He said, where the defendants fell down was in failing to discuss with Mrs. Birch the imaging methods and their comparative risks. For that reason, the defendant is liable to her for breach of duty. What we can see in these cases is an increasing level of recognition by the courts that patient autonomy and patient self-determination were and are important, which I applaud. Now, with that framework in place, we will now turn to the Montgomery case itself. The claim brought by Nadine Montgomery went all the way to the Supreme Court on appeal, a long and tortuous path for everyone involved. Because of the Montgomery ruling, Bolam no longer applies when it comes to consent, Montgomery introducing a new test of materiality. According to an article in the BDJ in 2017, the test of materiality is whether, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. The situation is best laid out, I feel, by the following 2016 quote by White. Patients are now entitled to receive any information they ask for in order to make their own decisions, regardless of whether the health professional would usually explain the nature of that information to the patient. Save for limited circumstances, this is also regardless of any professional judgment as to whether the information is relevant. The default position is now that information to be shared is what the patient wants to know, not what the health professional wants to tell. The prudent patient has arrived. The thing is, for dentists especially, this position already existed before Montgomery. Montgomery may have changed the things with regards to common law, but it can be strongly argued that the common law through Montgomery was only catching up to the regulatory guidance that was already in place. Both the GMC and the GDC had issued guidance about obtaining valid consent well before Montgomery appeal case occurred. The GMC, for example, were advocating obtaining valid consent as far back as 1995, although no real official guidance arrived until their 2008 guidance called Good Medical Practice and Consents, Patient and Doctors Making Decisions Together. Sounds nice, that, doesn't it? The GDC 2013 standard for the dental team also outlined what the dental regulator expects when it comes to the consent via Principle 3. I have several issues with the GDC guidance as it presently stands, and it's important to mention this because I think it directly reflects the problems I perceive with Montgomery. Firstly, there is the guidance 3.1.3. You should find out what your patients want to know. Now, how are we as clinicians supposed to do this? I can ask a patient countless questions, but I can never be sure that I've provided them with all the information they require. To highlight this, I don't even know what is going on in the mind of my own mother. Secondly, there is the guidance 3.2.1. You must provide patients with sufficient information and give them reasonable amount of time to consider that information. There's no definition of the word sufficient and reasonable. I mean, one patient will want to know everything whilst another won't want to know a thing. As this is a mandatory requirement by the GDC, it's a must. How do we as dentists meet this requirement 100% of the time? I would argue that perhaps it's not possible to do so. That being said, how do you get consent that is compatible with Montgomery? Well, it isn't easy. The fact that the medical field seems to be completely oblivious to it also represents a very real threat to the whole of the NHS, in my opinion. But that is a matter for another conversation. So we're winding down now, and just so you know, a good rundown on the legal basis for Montgomery was actually written by Andre Haig in the book The Dentist Survival Guide, which you'll be pleased to know can be bought on Amazon Kindle. Thank you.